Good morning, everyone. This is Brent Kynoch. I'm president of Kynoch Environmental Management. I am going to wait a couple of minutes for participants to join. I can see people joining right now before we actually get started. So if you'll hang on, we'll probably start in a couple of minutes. And good morning to all that are joining. We're waiting just a couple of minutes for to make sure everybody's watches are synchronized before we start the webinar. Well, good morning, everyone. It's a couple of minutes after 11, so I think we'll get started. I want to introduce myself. I'm Brent Kynoch, the president of Kynoch Environmental Management. And I am joined in the background, kind of behind the curtains, by my colleague, Megan Krause, who'll be watching for any questions that you might have during the course of the presentation. Please be sure to use the Q&A buttons or the chat buttons at the bottom of your screen. If you have questions, we'll certainly have time at the end of the webinar for all your questions. But if you feel that you need to get something answered right away, feel free to pop in and do that, and we'll do our best to get to it. So the title of our webinar is Lead Management 101. That is what we'll talk about today. And we're going to talk through a whole bunch of different topics related to lead and lead-based paint as we go through today. So first of all, let me start with the definition of lead-containing paint or lead-containing building material. And in short, that means that you've got lead that is equal to 0.5% or greater of the material being tested. The typical sources are lead-based paint, as you might imagine. And lead-based paint is most typically found in either a gloss or a semi-gloss coating on windows, trim, doors, exterior paint, and then metal structures. Metal structures can have very high concentrations of not only lead, but other heavy metals. And when I say metal structures or steel structures, think of things like water towers, bridges, things of that nature. We also can find lead on other painted surfaces. It doesn't just have to be semi-gloss or gloss paints. Any other painted surface pre-1980 might be a source of lead. We also find lead in the glazing of bathroom or ceramic tiles. I don't have down there, but you might find it also in the glazing of certain porcelain or pottery as well. And then we'll find lead in mechanical equipment. As I've said there, radiators, engines, things of that nature can be sources of lead as well. The way we test for lead to determine if we've got that, I'm going to go backwards, that 0.5% of lead, is we use an XRF device. That's the picture on your left. It's a non-invasive device that has a small radioactive isotope as part of the device. And it literally takes an X-ray, if you will, of the material being tested and can tell us whether there's lead in the material, and will tell us the percentage of lead as well. So we set the device up to read for a 0.5% or greater as well. These devices are great because, as I said, they're non-invasive, but they also read all the way through many layers of paint and all the way down to the substrate. And they automatically correct for the substrate as well, whether that might be wood or whether it's a drywall or whether it's a concrete surface. The device corrects for that based on software that's part of the device. The other way of testing is laboratory testing. We can literally collect a paint chip. If you see that painted surface where the XRF is being used, we could actually literally take a paint chip, use a razor knife, take a paint chip of that off, put it in a sealed container and send it off to the laboratory and have it tested by the lab. We also use laboratory testing for all of the dust sampling, lead dust sampling that we do, or for sampling for lead in water or lead in soil. Those all are done by the laboratory as well, typically. An XRF device can be set up to test for lead in soil, but most often they're set up just to test for lead-based paint. I want to walk you through the regulations relating to lead. First of all, that may be what many of you are interested in. We'll talk about regulations, and in the context of those regulations, we'll also talk about some of the requirements for lead-safe work practices. But on the federal level, behind federal regulations, we've got first the EPA, and you can see we've got 4 different regulations there. I'll talk about each one of these individually, but walk you through. We've got the RRP rule, which is the renovation, repair, and painting rule that applies to target housing and child-occupied facilities. I'll describe that for you a little bit more. There's a training and certification rule that's part of the Toxic Substances Control Act, or TSCA, which requires that all the people involved in disturbance of lead-based paint, whether it be an inspector or a risk assessor or a contractor, need to be trained and certified to do that work. There are disclosure requirements under EPA and also under HUD. We've got kind of a dual-headed monster on the Title 10. The Title 10 is simply a requirement to disclose the possibility that lead paint might be present in any real estate transaction for any building that was built prior to 1978. And then we've got hazard standards and clearance levels, which you can see is also part of the Toxic Substances Control Act. In Section 403, if you look above, it noted that the training and certification is in 402 and 404, and then stuck in the middle of that are the hazard standards and clearance levels. And we just had a change in these standards and clearance levels that occurred in December of last year. Was promulgated in 2019, took effect in 2020. We're going to talk through what those standards and clearance levels are as well. Also under the federal jurisdiction, we've got OSHA. And for those of you who don't know, OSHA really manages the relationships between employers and employees. And so OSHA has a lead in construction rule to protect workers who might be working with or disturbing lead materials, lead-based paint, lead piping, anything that might have lead. So there are requirements there to protect those workers, and there are also some limits, some airborne lead dust limits as part of that. We'll talk through that. And then under HUD, we've got a lead safe housing rule, and that applies to federally owned or assisted housing. I did mention Title 10 as well under EPA, but the lead safe housing rule sets up standards around, as it says, they're federally owned or assisted housing. And depending on what kind of housing and how much assistance, there are specific requirements under these HUD rules. In some cases, it requires that actually all lead be removed from housing, in federally owned housing. In other cases, it simply requires that it be managed in place and that there are routine re-inspections to assure that any lead painted surfaces are still intact and not becoming hazardous where they can release lead dust. From the state perspective, we're going to talk today a little bit about the Maryland regulations and the District of Columbia regulations around lead-based paint and the requirements there that might be of interest to you. We will not be talking about the Commonwealth of Virginia because they don't have any specific regulations as they might apply to you. Certainly Virginia mimics or is required to follow what is included in the federal regulations, but Virginia has no other specific regulations to speak of. Before we get into me discussing each of the regulations and what it means to you, let's talk a little bit about the health effects associated with lead and lead exposure, because heck, that is the reason we're doing all of this after all. As the slide shows, the way that lead can enter our bodies is through inhalation, ingestion, or skin and eye contact. Inhalation, I think that's pretty straightforward. Ingestion would simply be literally if you put something in your mouth that might have lead dust or be lead containing in some way. And you can see the organs that are typically affected by elevated levels of lead in the blood. And you see also there what can be affected in our bodies. In short, here's what happens. When one gets an elevated blood lead level, it inhibits the ability of the blood and the hemoglobin to absorb oxygen. So since it can't absorb oxygen, it can't provide the necessary oxygen to the brain and to other organs, which can cause developmental issues with the brain and other anomalies associated with brain activity. And then as you see there, can result in slowed growth, hearing problems, headaches, so on and so forth. And unfortunately, the nature of the chronic is that it's a cumulative effect. So if you have some lead exposure and then you don't have any for a while, but you come back and you have more lead exposure, you're going to find that those health effects just add on top of each other. In other words, it doesn't go away without specific action to remove the lead from the blood. But this is a flyer from the CDC, and I wanted to share it with you while we're talking about health effects. And the CDC says the same thing. Clearly, and I think probably all of us know it, we seem to be most concerned about lead poisoning and lead exposure to children. The reason is because as their bodies are developing, if they have a lack of oxygen to the brain and to other organs, they're going to have developmental concerns as they are growing and developing that can result in lower IQ, can result in underperformance, can result in other behavioral or learning problems, or even hearing and speech problems in the worst type of cases. As noted in this graphic here, lead-based paint is the most likely source of lead exposure or lead poisoning, not only for children, but for anybody. And typically, that exposure comes from a dust associated with the lead paint. And that might be when two lead painted surfaces, like a door or window frames, rub against each other. Imagine opening and closing a door where the door rubs against the door frame because it's been painted many times. And every time you open or close the door, we're scraping some paint off of both the door and the door frame. Same things happens with windows as well. As we might raise or lower a double hung window, if that window, that painted window, is rubbing against the painted frame or sill around that window, we actually can create dust as those two surfaces rub together. And typically it's the dust that's creating the exposure. I know many of us have heard about children who might, teeth or walk over to a windowsill and bite a windowsill. That's a little bit of a misnomer because most of the exposure is going to come from dust associated with friction surfaces that are lead painted. We can also see lead exposure caused by leaded gasoline, which is now has been outlawed since the 70s, and any other industrial processes where lead might get in the air and then settle in the soil. We can find lead in water supply piping, and I'm sure all of us on here today remember the crisis in Flint, Michigan, where a change in the pH of the water allowed for a little bit more of an acidic pH, which allowed the lead as part of the piping to leach out and to get into the water supply. Kind of the simple answer there is in most cases, most water supply utilities try to keep their water supply a little bit on the basic side of the pH scale. And what that means is that we might get a calcium coating on the inside of a pipe when we've got a little more on the basic side as opposed to leaching the lead out of the pipe and into the water supply. You probably have also heard about older or imported toys that might have been painted with lead-based paint or glazed with a lead-based paint glazing, and also metal toys and jewelry can be another source of lead exposure as well. Again, we're talking about typically dust from these as the paint degrades. The good news is, and this is again from a CDC flyer, lead poisoning is 100% preventable. I want to make that very clear today because all of this is preventable, and all of us involved in this webinar need to be doing our part to really try to prevent lead exposure, which might result in lead poisoning. How do we do that? Well, it's all about being proactive. I know the flyers that came out from KEM about joining us for the webinar today talked about our proactive approach to lead management, and it's all about being proactive. And if you understand the regulatory requirements, if you understand how to prevent exposure and you do your part in this regard, that puts you in a proactive frame of mind. And by doing that, we can prevent lead dust, which results in lead exposure, which can result in lead poisoning of both children and adults. So going back to our regulations, I want to walk you through each of these regulations and talk about what the salient part of the regulations are and what it might mean to you and your colleagues in your business. And we can talk through these again through the Q&A period at the end as well, if you do have any specific questions. The RRP regulation was passed by EPA just a little more than 10 years ago. And as I said before, it's the renovation, repair, and painting regulation. And in short, it was EPA's attempt to try and cast a pretty big net to try and prevent contractors from producing lead-containing dust as part of their work, which then might be ingested or inhaled by either adults or children. The RRP regulation applies to any activity that would disturb lead-based paint in target housing or in child-occupied facilities. And target housing is defined as any house or apartment built before 1978. There are some exceptions to that, but in essence, the simple way to describe that is target housing means any house or apartment built before 78. And the regulation kicks in anytime more than 6 square feet of paint or 20 square feet of paint outdoors, 6 square feet indoors, 20 square feet outdoors is being disturbed. And if you're disturbing it as a homeowner, the RRP regulation doesn't apply to you. But for someone doing the work for compensation, the RRP regulation applies. And the rule specifically says that for compensation includes landlords. There were questions when the regulation first came out from many landlords, property managers that said, hey, we've got a maintenance person on staff and they're going in to do work in the apartments that we manage. We can't really say they're doing the work for compensation. They're an employee of the firm. But the regulation very clearly states that landlords doing work in tenant occupied facilities, it does apply. If you're a homeowner and you have someone coming in your home to do work, and they would disturb the 6 square feet or 20 square feet outdoors, the RRP regulation does apply for that work being conducted. And here's what the regulation requires. It requires that the firm doing the work is certified by EPA, and that there is an individual or individuals within the firm who are individually certified. In order for a firm to become certified, they have to have at least one person certified within the firm. And then that person is considered a trainer for the firm and then trains other persons in the firm on appropriate lead-safe work practices. Back to the scenario I described earlier, if in fact you're bringing someone into your home to do some work, they should be giving you the pamphlet that you see down there below that says Renovate Right. They should be using lead-safe work practices. Before they actually start the work, they're required to test the paint to determine if it is lead containing, which would then kick in those work practices. And then after they're done, there's a cleaning verification step that these contractors must go through. So as going back to my earlier slide, this applies again to 6 square feet indoors or 20 square feet outdoors. Any house or apartment, any housing or any child occupied facility built before 78, and all of these steps are required. So the training and certification rule under EPA, moving on, involves any person that's involved in target housing or child occupied facilities has to be certified. So anybody doing work in these facilities as an inspector or as a risk assessor, or if they're doing lead-based paint abatement, supervisor or worker, all these people need to be trained, certified, and licensed in order to conduct the work. Now, this is the abatement supervisor and the abatement worker is a little different than what's required under the RRP regulation. In the RRP regulation, it applies to a firm who might be doing work for you, where the work is not simply the removal of a lead-based paint hazard, but maybe they're doing electrical work. Maybe they're renovating and tearing out some walls that are coated with lead-based paint. So the result of their work is not lead-based paint abatement, but they're going to be disturbing lead paint as part of their work. The RRP regulation applies there. If in fact we're removing lead-based paint to remove a lead-based paint hazard, then we're looking at what would be termed abatement. And there are additional training requirements for abatement workers and supervisors. Also, I mentioned under the EPA regulation, we've got the Title 10 disclosure regulation. And again, the target date is 1978. And this disclosure requirement says that buyers or renters of any pre-1978 housing they need to receive information about lead hazards prior to engaging in a contract. Now that means either a contract for sale or a lease agreement. They need to be informed about lead hazards. And this is typically the brochure that one would get. So the National Association of Realtors has done a great job of working with the real estate and realtor community to make sure that if you're in the process of a transaction for buying or selling a home and it's pre-78, they have a box that they check, so to speak, and they distribute this information typically as part of closing. So you'll see it that way. And then in a similar fashion, there are requirements for disclosure in terms of rental agreements and lease agreements. And when I talk a little bit about the DC regulations, you'll see that DC has even additional requirements around disclosure in rental agreements. So the hazard standard and clearance levels, I mentioned to you earlier that these were just updated just a couple of months ago in December of 2020. And it says that when one is conducting dust samples to determine if an area is free of a lead dust hazard, or at the conclusion of a cleanup activity or an abatement activity, those dust levels need to be 10 micrograms per square foot or less on floors and 100 micrograms per square foot or less in windowsills. And this was a pretty significant reduction. I didn't put the prior ones up there because I didn't want to have confusion around the slides, but I'll share it with you verbally. Prior to December 2020, the dust clearance level for floors was 40 micrograms per square foot and 250 micrograms for windowsills. So these are pretty significant reductions, all aimed at reducing the incidences of lead poisoning, especially in children. What really the CDC has said is there is no known safe level of exposure to lead or lead dust, so they've lowered these levels. You'll find that both Maryland and DC have adopted these levels in their clearance requirements as well. So the clearance is if I'm in a facility or a unit or a house testing to see if there is any lead-based paint hazard, I've got to meet these levels, and after an abatement or cleanup activity, I've got to meet these levels as well. OSHA, I mentioned earlier, OSHA governs the relationship between employers and employees. And in short, as with most OSHA regulations, they have a PEL or a permissible exposure limit. And in the case of OSHA, they are looking at not lead dust, but they're looking at airborne measurements of lead that can be inhaled by a worker. So OSHA has set a PEL or permissible exposure limit for lead dust, airborne lead dust of 50 micrograms per square meter. That should actually say per cubic meter. I apologize for my mistake there, per cubic meter, and the action level being 30 micrograms per cubic meter. Air monitoring is required of any worker who might be working with lead in any detectable concentration. The reason I have that there, and the reason that's important is, you'll remember right at the beginning of my presentation, I said that the definition of a lead-containing material is 0.5% lead by weight. OSHA says if there's any detectable concentration, I've got to do air monitoring to make sure that the worker is not exposed above either the action level or the permissible exposure limit. OSHA also says if we are disturbing building materials that contain any concentration of lead, I've got to do this exposure assessment, the air monitoring. I've got to provide training. I've got to provide hygiene facilities for the workers. That would be to wash their hands and faces. They need to use certain safe work practices, including personal protective equipment. And there's an entire medical monitoring portion of the OSHA regulation for persons who might be exposed to lead in construction. Disturbance of lead includes all the things you see there: manual scraping, sanding, drilling. Anything that would disturb lead-based paint is covered under the OSHA lead in construction standard. Disposal. EPA has specific disposal requirements, both under the RRP and other rules. And then you might also be required to perform toxicity characteristic leachate procedure testing, or TCLIP testing for short, on the waste stream for disposal. Keep in mind that all these regulations that I've described to you, with the exception of OSHA, apply really to target housing and child occupied facilities, and there are specific disposal requirements for lead in those cases. But If I'm working in a commercial building or facility, some of these regulations don't apply. However, the disposal requirements do. And it's going to require that you test the waste stream to determine if lead might leach out of that waste stream, could leach into a groundwater supply or something of that nature. That's called a T-clip test. Let me walk you through the local and state regulations now. And I mentioned earlier, Virginia doesn't have any regulations, so I'm really going to walk you through DC and Maryland, and we'll talk about these regs as well. So the DC regulations have been in effect for about 8 or 9 years now. And there are some very interesting portions of that regulation that I want to share with everyone here that I think might be applicable to your work. It says that if the DC government believes that there is a risk of a lead-based paint hazard in any dwelling unit, they have the right to enter that unit and check for a hazard. I want to say that again. If DC has any reason to believe that there might be a risk of a lead-based paint hazard, they have a right to enter that dwelling unit and check for a lead-based paint hazard. Pretty broad scope there. The District Department of the Environment, or DDOE, the district government, can also order the property owner to do whatever it takes to eliminate any lead-based paint hazards and underlying conditions as part of this belief. So going further, as I said earlier, if DC believes there's a lead-based paint hazard, they can enter the property. And reasonable belief could be a call from a tenant. If a tenant calls and says, hey, I've got peeling paint on the baseboards in my rental unit, somebody from the District Department of the Environment could enter that unit and check as well. If they see peeling paint or paint chips or dust, they can order a cleanup and they can extend it to the entire structure. Now, there's a presumption in DC that if the building was built prior to March 1 of 78, so again, here we are at the 1978 rule, that there's a presumption that it contains lead. So imagine a tenant calls, they're in an apartment building that was built in 1975. They've got peeling paint. They call and say, I've got peeling paint. Well, there's a presumption right away that that paint contains lead. And if it is peeling, then the district can order that paint needs to be cleaned up and repaired so that it doesn't peel and doesn't release lead dust. The only exemption to this is if a testing has been done by a certified lead inspector or risk assessor using, again, something like an XRF device that you see in that picture to test and prove that there is no lead-based paint present. So again, I keep saying this, but I want to make it very clear to you. If any of you are property managers or involved in property in the District of Columbia, there's a presumption that if the building was built before 78, all the paint is lead. If it's peeling, it's a hazard. If it's a hazard, it has to be repaired. And the only way to prove that that's not a hazard is to prove that it's not lead-based paint. All right. Turnover requirements in DC. Turnover requirements are this. Anytime an apartment or a rental unit is turned over in the District of Columbia, a clearance report must be provided to the new tenant that's less than 12 months old. And the clearance report involves lead dust wipe testing throughout the unit. There needs to be testing in every room of the unit. So even if you have a 1-bedroom apartment, you're looking at a test in the foyer, you're looking at a test in the kitchen, you're looking at a test in the family room, you're looking at a test in a bathroom, you're looking at a test in the bedroom. So there are several areas. Every individual room or area of the apartment needs to be tested. Now, the regulation specifically says that clearance report is required if the occupant or a regular visitor could include a pregnant woman or a child under the age of 6, or if the tenant requests it. Here's what we have found very interesting, especially with our clients. Since you can't ask an applicant if they're pregnant, and we've got all these fair housing rules in place. In essence, you probably should be testing every time you're doing a turnover. The other issue is this: if you've got a series of units that are have been turned over and you've renovated them, you've painted them, you've cleaned them up, you're ready to lease them. If you do have someone come in that meets this criteria, a pregnant woman or a child under the age of 6, and you haven't tested that unit, then you can't have them sign a lease until you have the testing and you provide it to them. So you've got to provide that clearance report to a tenant or a potential tenant prior to them engaging in the contract, unless it's a lead-free unit and it's been done by the testing, or, and this last one is now in play because the regulation has been in place long enough. If you have 3 clearance reports that were each issued 12 months apart in the previous 7 years, then you do not need to provide a new lead clearance report. And you're going to look at 7 years from the first clearance report is your period of time. We have several clients that are in this situation right now, and they're turning over a unit, and we find out that, nope, you've tested it 3 times in the last, let's say, 4 years, so you don't need to test it again, and can save you a little bit of money. DC also has a tenant rights form. I did talk about disclosure requirements under Title 10, but DC has its own tenant rights form, disclosure form that you can download from their website. It's 4 pages. It's a fillable PDF, and this is all part of a lease requirement for any pre-1978 building in the District of Columbia. In Maryland, we've got specific requirements for rental housing as well. And the Maryland regulations apply to all rental housing built before 1978, and even applies to single family homes. Really important here. Not just multifamily, but also single family homes. Let's see. Do I have a question that has come in? I will get to that question in just a bit, if you don't mind. Maryland requires that you register the property with the state. So every property that in Maryland, every rental property that was built before 1978 must be registered with the state. Even if it's lead-free, it has to be registered with the state. Again, you've got to distribute the tenant education material, the EPA pamphlet. You've got to perform lead dust testing at every turnover. Maryland does not have the provision that DC does for if you've done 3 tests in a period of 7 years, you don't need to test anymore. Maryland says you've got to test at every turnover, even if that turnover is less than 12 months, or maybe it's 4 years, it's a turnover. And turnover is important here. In Maryland, the turnover is defined as a new tenant entity. So if you are simply renewing a lease, that does not qualify as a turnover. The Maryland regulations also have specific requirements in the event that an occupant has an elevated blood level. And in short, it would require the landlord to move the occupant out of the rental or dwelling unit to clean the unit and essentially perform lead-based paint abatement before we move an occupant back in. In other words, Maryland would have a presumption that the dwelling unit is the source of the lead poisoning, unless, of course, we prove that there is no lead present. Exemptions under the Maryland regs for hotels and motels. And again, if a property has received a lead-free or something called a limited lead-free certificate. And here's what limited lead-free means. Limited lead-free means there's no lead-based paint on the interior of the unit or the building that the unit is in. If there is lead-based paint on exterior components, even if there's none on the interior of the building, but there's lead-based paint on the exterior, you still have a requirement for testing. It's called a limited lead-free certificate. We're finding that a lot of people in Maryland, if they just have exterior lead-based paint, are doing what they can to get rid of that paint so that they can eliminate testing in the future. And in DC, we don't have that requirement. In DC, if there's paint on the interior or the exterior, the dust testing is required. The dust clearance levels, I'm pointing these out to you again. These are the new ones that went into effect in December of 2020. And 10 micrograms per square foot on floors and 100 micrograms per square foot on windowsills. What does all this mean to you? You saw this earlier from me. It means being proactive. Understand the regulatory requirements, understand how you're going to prevent lead exposure, which in short is preventing lead dust or the creation of lead dust. And if you do your part, we all do our thing. That concludes my portion of the presentation. I'm certainly in a position to answer questions right now. And first question, does the turnover requirement apply to all buildings or only prior to 3/1978? DC says March of 1978. Everybody else, EPA, Maryland says January 1 of 1978, if that answers your question. I certainly am able to answer any other questions if anybody has some. I don't see any other questions coming in. I want to thank everyone for joining me today. We've all been blessed as part of the pandemic with learning how to Zoom and how to have video meetings, and it's allowed us the opportunity to provide webinars where we might have prior have come into your place of business and provided a training seminar, but we hope those take the place of it. All of our webinars are available as well. We record all of these. This is our third webinar in the last several months. We've provided one on mold, we've provided one on asbestos, and this one today on lead. Thank all of you for joining us today, and seeing no other questions, I'll say goodbye. I'll say stay warm, be safe, don't slip and slide on the ice, and I hope everyone has a great weekend coming up. Bye-bye.